Well, hello, you. How have you been? I hope you've been amazingly wonderful. I have an announcement for you today. EETV now offers memberships. You should see the Join Now button, and if you become a member, or what I like to call the EETV tribe, you will get exclusive content, motivational Monday chats with me, vlogs, and also mukbangs. So, yes, check it out. Along with each tier of membership, there's, of course, different levels of access and even the option of having a monthly phone call with me or doing video collabs with me. So, check out how to become a part of the EETV tribe. For those of you who have said you would like to see a different side of me, you'd like to see more Felicia and less Attorney Pearson, well, here's your chance. Check us out in the membership options by clicking the Join Now button. I hope you become a member of the tribe. See ya. All right. Hello, hello, hello. If you can hear me, please put a Y in the chat. As you can see, I'm in a bit of a different atmosphere. I don't have my usual setup. I'm visiting family. So we're going to have to be flexible today, right? I came outside for natural lighting since there's no ring light. And that does mean that you may hear some of the typical urban area pleasantries going on outside, right? So if you can see me and you can hear me, put a Y in the chat. And once I know that everyone can hear me and see me, we can get started. As I said, we got to be flexible today. We got to roll with it today. We have a different atmosphere, right? And so we're just going to do the best we can with what we have. All right. All right, so I see everyone saying that they can hear me. I want to give a shout out to one of our members here today, Senorita Flower 72. Hello, thank you for coming through. All right, I see the Y's coming in that all of you can hear me. Okay, awesome, awesome. All righty, so before we get started, I have a few housekeeping things just to mention to you. All righty, so Empowered Esquire will be launching a podcast. So we will have, it will be on Anchor. The app is called Anchor. So I will be providing you all with the link to the app where you can download the podcast, right? We'll, of course, explore similar topics, but not the exact same topics that we actually explore here on the channel. And for those of you who don't want to have to download Anchor and go onto a different app, the podcast episodes will be uploaded to a separate channel here on YouTube. Okay, so just look out for that because we'll be launching that pretty soon. And if you see my eyes dart over here, you know I'm in dog mommy mode as well because Mac is out here playing in the front yard, so I have to keep an eye on him. All righty, so let me do some quick shout outs in the chat. I realize I haven't really been able to do that in our past couple live streams. Okay. All righty. Hello to Karen J. Hello to Nappy Yankee. Hello to Nappy Yankee. Why is it that I don't see? Oh, because I'm not on my phone. I was going to say, why is it that I don't see your moderator stuff? Hello to Enter the Crisis. I think you're new, right? I think you're a newbie. So hello to you. Hi to Eric Summers. Eric Summers says he's looking forward to the podcast. Absolutely. Okay. So you guys know our topic for today is the artist known as Afrika Bambaataa and the Zulunation. They have been sued by a man who is alleging that he was abused by them in a blank manner. As you know, here on this channel, we try to stay away from certain words because we don't want Miss Algorithm to get us, okay? So we have a super chat from African Cannibal. Thank you for the dollar super chat. And you just reminded me, let me go ahead and put my Cash App in the chat. I will be checking my Cash App, okay, and I will be thanking those who send me a Cash App on air. So if you send a Cash App and you do not want me to say your name, you do not want to be mentioned, you want it to be anonymous, all you have to do is put a NA in the description of your Cash App, And I'll know that you want it to be anonymous and you do not want me to mention your name during the live stream. Okay? Alrighty, so let's get into it. So first, we're going to read an article about this entire case and what's going on, right? We'll have a chat about what the media is saying about this case. And then I have a treat for you. We are going to look at the actual lawsuit that was filed in Bronx County. Yes, that's right. You know, in other places, in other channels, elsewhere, it is based upon he say, she say, but you know how we do it over here. We talk the facts, right? So we're going to look at the actual lawsuit after we explore a brief little article about the lawsuit and see what the media is saying. Because, you know, it's important to know what the media is saying about a case. And the reason why that is important is because the media frames these cases, right? So whatever happens in court, we know that that is the law of the case. But when we talk about public perception of a case and how public perception can, you know, actually hinder and change the evolution of a case, then it's important to know what the media is saying, because the media frames that. The media frames public opinion. And I think something that we've prefaced on this channel here before is how the media can at times, in fact, sort of convict someone, right, when they're supposed to be innocent until proven guilty. So it is important that we know what the media is saying about this case. All righty. So I'm going to take down, listen, work with me on the video. I hope that I'm not looking crazy here, because I'm going to take down this video that's on the side. Okay, and we are going to share my screen so that you can see this article. Oh, one moment. Uh-oh. The article is not yet queued up, although I thought it was. One moment. All right. Is this it? Let's see. Okay, yes, this is it. All righty, so here we go. Share screen. Hello to Sky Fearless. Thank you so much for the compliment. We're rocking and rolling today and being flexible today. All right, so let me see what you are seeing. Let's make sure that you are getting a good view of the article. Okay. All right, that works. That works. Let's take down this little comment just for a second, just so you can really see. Or actually, this might be better, right? If I give you full screen? Yeah. Okay. Here we are. So, Afrika Bambaataa suit. Oh, and another thing I should mention, my Wi-Fi is spotty here. So, again, work with me. We're not at home. We're not having our usual setup, right? Okay, Afrika Bambaataa sued for blank abuse and trafficking. We're here on Billboard.com checking out what the media is saying about this case before we dive into the actual lawsuit that was filed. Okay. All right, so this is a picture of Afrika Bambaataa here. You know, I'm sure that many of you are familiar with him from his younger days. So this appears to be a more recent picture. This was 2011. Okay. And Mac. Mac, we're live. Be polite. An anonymous victim claims he was blank abused and prostituted, wow, as a minor by hip-hop pioneer Afrika Bambaataa in a lawsuit filed last month. In the lawsuit, which was filed in New York on August 9th and obtained by Billboard, the John Doe plaintiff claims that for years beginning in 1991, when he was 12 years old, he was repeatedly blank abused and blank trafficked at the hands of Afrika Bambaataa. Bambaataa, known for his influential 1982 single Planet Rock and for founding hip-hop organization Zulunation, is referred to in the lawsuit by his birth name, Lance Taylor. Billboard's multiple attempts to reach Taylor for comment were unanswered at press time. Tanner and Ortega, the law firm representing Doe, did not immediately respond to a request for comment. And the train is coming by. The lawsuit claims that after Doe attended Zulunation meetings, Taylor began inviting Doe to his apartment several times a week and encouraging him to use a gym on the premises, where Taylor would comment about plaintiff's muscular body and would touch plaintiff on the shoulders, biceps, and torso. Remember that Taylor is Bambaataa, okay? Remember that. At Taylor's apartment, Taylor began touching Doe's private areas and encouraging him to blank while watching blank videos together. The lawsuit alleges that the mutual blank later progressed to blank. The lawsuit claims that Doe is also a blank trafficking victim, as Taylor allegedly transported Doe to other locations and offered Doe for blank to other adult men in exchange for money. In exchange for money. I have to repeat that again. During these encounters, Taylor would watch as plaintiff would be blanked by other adult men. Doe claims that he suffered physical injury, severe and permanent emotional distress, mental anguish, depression, and embarrassment as a result of the alleged abuse. He also alleges that he was prevented from obtaining the full enjoyment of life and has been unable to keep a steady job. This led to a loss of income and or loss of earning capacity. I'm going to hop in the chat, see if there are any questions thus far before I explain to you why it is that John Doe is kind of listing all of the ways that he has been affected by this. Okay, so I'm cheating a bit. I'm on my cell phone here, taking a look in the chat. So Eric Summers has a question. He says, why a civil lawsuit and not a legal case? Interesting, but you never know. Perhaps John Doe went to the authorities and the authorities decided that they did not want to press criminal charges. Okay, that is possible. All right, so why is John Doe detailing that he has physical injury, that he has emotional distress and mental anguish and depression, right? Because he has to establish injury. Injury is an element in every lawsuit. Why? Because if you were not injured in some way, you do not have the right to sue. So John Doe is establishing that he has injury. He says physical injury, emotional injury, mental injury, and he also says that he lost wages. These things establish that he has the right to sue, and also they provide the premise for him to say that he should be paid damages. So the court, if damages are awarded in this case, right, they would look at things like loss of wages, since that is what John Doe is alleging. They would look at, well, what could John Doe have done for himself financially were he not to have been injured and crippled by these things that happened to him? And these are things that the court can use to actually quantify how much money is appropriate for damages. So that is why in these types of lawsuits, you will always see the plaintiff talking about losing something that is in some way tangible, because that is the hint for the court. Hey, this is something you can use if you decide to grant me any type of financial damages. All right. Okay, so I'm going to stop sharing for a moment. I'm going to come back over into the chat, say hello to everyone, and see what's going on. As you know, I don't have my usual setup here, so we're going to try to make sure, you know, that we keep it as flowing as we can despite that. Okay. Alrighty, so if anyone has a question about the article that we just read, if you have any thoughts, any comments about the article, let me know before we dive into the actual documents that were filed in Bronx County in this lawsuit. Okay. Now, I do want to say to everyone in the chat, if you have some preconceived notion, right, about who Afrika Bambaataa is and about the Zulu Nation and what they are about, and that's led you to feel some type of way about this case, I would encourage you, as I always do, to try to be unbiased, to try to be impartial, to try to remove yourself from this case, right? Remove yourself and just see it as an observer from the outside looking in, okay? And I also want to take this moment to say, We've been covering quite a few cases like this on this channel lately, and they are heavy topics with people who were actually harmed in these cases. And if you are someone who has experienced this, who has been through this, my heart goes out to you. And if you haven't told someone, I hope that at some point you feel comfortable enough telling someone what has happened to you. Okay. Alrighty, so I don't see any questions about the article. So let's go straight into the actual lawsuit. I'm going to share my screen. How are we going to do this? We'll do window. Yeah, because then I can pull up that window. Perfect. All right, so you should be seeing this window here. I'm going to take a look down at my cell phone just to see if you are seeing. Perfect. All right. And I think I'm going to go ahead and maybe make this your entire screen, right? Just show you the lawsuit. You don't have to look at me. Let's do this. Perfect. All right. Hello to Sidbo. Sidbo says, hey, Empowered Esquire, sliding through to salute you. Salute to you as well. All right. So here we are. Everyone, this is it. This is the actual lawsuit that was filed in the Supreme Court in Bronx County on August 9th, 2021. As you can see, the plaintiff is John Doe. For those of you who may not know, you can actually file a lawsuit without giving your name to the public. So the court will know the name of the plaintiff, and the court can keep that confidential. And a lot of times in these types of cases, it is not out of the ordinary for the plaintiff / alleged victim to file as a John Doe for the purpose of protecting their identity and making sure that they're not, in some way harmed or harassed or anything of that nature. Okay. We have another $1 from African Cannibal. Thank you to you. We appreciate it. Again, for everyone who's interested in giving, my Cash App is pinned. Cash App is also an option. And if you do Cash App me, please put an NA in the Cash App description. If you do not want me to thank you live on air. Okay. Thanks again to African Cannibal. All right. So let's dive into this, shall we? Here we go. Let me make sure I have it on hand. Okay, so we see John Doe. Well, you know what? First of all, let's take it from the top because some of you are OGs, true, but some of you might be newbies. So let's take this from the very top with the case caption and everything else we're looking at. And by the way, if you prefer, you know what? Let's do a democracy here. All right, so if you prefer this view where you can kind of sort of see me, but you can also see the lawsuit, give me a 1 in the chat. If you prefer this view where you're just looking at the lawsuit, no distractions, give me a 2 in the chat. Okay. So 1 in the chat if you prefer this view where we're kind of chit-chatting, but you're also seeing the lawsuit over here, totally not over there. Give me a 1 in the chat. And a 2 in the chat if you just want to see the lawsuit. Okay. All right. So I see a 2. I'm seeing quite a few ones. Okay, and shout out to everyone in the chat as well. True Soldier, Marlon, Dicky, Honeybee, QT, Lue. Lue, you're not actually voting, Lue. All righty, so it looks like everyone wants 1. Okay, so this is it. Here we go. You still see the lawsuit, but you also get to see me expounding and explaining and pontificating and elaborating. All right, let's dive in. So this is the case caption, right? When you see the Supreme Court of the state of New York, County of Bronx, right? John Doe, you see up here a NYSIF number. That is a number that is used in the New York state system to identify documentation filed in lawsuits. Okay, so we know that this is doc number 3, which means there are other documents filed in this lawsuit. Okay, you see the index number. Now, why is the index number important? Here is why. The index number is how the state identifies this lawsuit when it comes to people who are looking to either file things within the lawsuit or just to find the lawsuit. So if you as the public would like to search for this lawsuit, you could go online to eCourts for the state of New York. You could type in this index number here, right? And you could actually pull up all of this documentation yourself. You could actually see what is happening in the case yourself. Okay. And then received means that's the date it was filed. Okay. And we see amended complaint. So we know that very likely, this was not actually the first complaint. This is an updated version. And we know that's very likely because we see amended complaint, amended, right? And not just complaint. Okay. Here we have Lance Taylor, aka Afrika Bambaataa, aka Afrika Bambaataa Asim, aka Kevin Donovan. Interesting. If his name is Lance Taylor, where did Kevin Donovan come from? Huh? AKA Asim Bambaataa Bay, AKA Bambaataa Kayan Asim, AKA Chief Dragonfly. Wow, lots of names here. And then we see that our second defendant is Zulunation. Our third defendant is Universal Zulunation. And the fourth defendant here is XYZ Corp. So John Doe sued Afrika Bambaataa, Zulunation, Universal Zulunation, and XYZ Corp. Okay, let's keep it rolling. Plaintiff John Doe, by his attorneys Tanner and Ortega LLP, complaining of the defendants, respectfully alleges. Okay, so this just means, hey, plaintiff John Doe is submitting this complaint to the court via his attorneys Tanner and Ortega, and here is what he is submitting to the court. Okay. Then you get into the nature of the action. The nature of the action is where the plaintiff begins to explain what law and what allegations are supporting them bringing this lawsuit. Okay. I'm going to take a quick break just to hop into the chat, see if I have any questions thus far, and I do not. So we're back into it. This action is brought pursuant to the New York Child Victims Act. So there we go. We first have the law, right? CPLR section 214-G. So that's the actual law, you guys. The CVA opened a historic 1 year, one-time window for victims and survivors of childhood sexual abuse. I use the word, in the state of New York to pursue, Mac is at it again, you guys. One year, one-time window for victims and survivors of childhood blank abuse in the state of New York to pursue lapse claims. Prior to the passage of the CVA, each plaintiff's claims were time barred the day they turned 22 years old. So pause. Let me elaborate and explain for you for a moment. So previously, the law said that up until a certain age, a person could sue for things that happened to them when they were a minor, okay? And originally, that age was 22 years old. Now, for those of you who do not know the history and the policy behind the Child Victims Act, allow me to enlighten you, right? To empower you with knowledge, because that's what we do here. So, all across the country, there was a wide protest regarding a lot of the statute of limitations for childhood abuse. The reason being, there was a large movement by victims of the Catholic Church, because a lot of these victims were alleging that, you know, when I was an altar boy or when I went to Catholic school, right, these things happened to me. And now I'm 52 years old. Now I'm 45 years old, right? And I finally have the fortitude. I finally have the confidence. I finally feel safe enough to talk about what happened to me. And it's unfair that someone could victimize me when I was a child, and then by the time I'm 22, I have to be ready to talk about it, right? And so that movement, right, with that policy, that spirit behind it that I just explained to you with a lot of the victims of the Catholic Church, that was the big push to start amending the statute of limitations. And that birthed the CVA. And the fact that the CVA has extended the age to allow people who are older than 22 to seek, you know, justice or seek remedy for things that happened to them when they were a minor. Okay. All right. I'm here in the chat. Jamar says, who's fussing in the background? So Jamar, I see you're a newbie. Welcome. I have a little 4-pound Yorkie who thinks that he is a Rottweiler or a pit bull. Okay. And so we're visiting family. So we're out, you know, on the front porch. We're not in my usual setup. And as other dogs pass by, as anything interesting passes by, my 4-pound Rottweiler will attempt to protect me. Okay, so we're being flexible today. We have a super chat from Senorita Flowers. Thank you for the $25. I appreciate it. Okay. So if everyone's okay with the policy of the CVA, if everyone understands the policy of the CVA, give me a Y in the chat. If you have questions about the policy behind the CVA and why it was extended, why the time was extended, drop your question in the chat. All right, I'm going to check my Cash App really quickly to see if I have anyone that I need to thank. All right. All right, I don't see any Cash Apps as of now, okay? Alrighty, so I see Nappy Yankee has a question. Nappy Yankee would like to know, can a John Doe remain anonymous forever? Or does he eventually have to be revealed, especially if they become of age? So a John Doe can remain anonymous forever to the public. So forever and ever and ever and ever, when someone looks up this case, they can see John Doe. And to the public, it's just John Doe. Now, to the defendants in the case, John Doe would have to eventually make himself known, right? That would be a part of discovery. But the court would direct the defendants not to make public these confidential exchanges. Okay, so to the public, someone can be John Doe forever. To the defendants, no, because defendants have a right to know who is bringing a claim against them. That's part of your rights. If someone sues you, you have a right to know who they are, why they're suing you, and what basis they're suing you on. All right, we have a comment from Caden Pat. Caden Pat says, sad to hear of this lawsuit since I was a huge Bambaataa fan. Well, you know, I think I've said this before, and I'm going to have to say it again. There's a certain sector of our community that I think has a problem, you know, and people have been covering it up for years, and now it is coming to light. You hear all of that? You love that. You love that Brooklyn vibe, right? I love Brooklyn, though. Brooklyn isn't bad. All right, so let's get back into the lawsuit. Okay, so paragraph 2, from 1991, when the plaintiff was merely 12 years old, to 1995. Okay, so plaintiff is alleging 4 years of abuse. The plaintiff was repeatedly blank abused and blank trafficked at the hands of defendant Lance Taylor. As a result of the passage of the CVA, plaintiff, for the first time in his life, can now pursue restorative justice. Plaintiff brings suit to vindicate his rights. All righty. So now we have the parties. Okay, so we have an explanation of who all these different AKAs are, right? So we see them explaining here in paragraph 5 that all these AKAs are actually Lance Taylor. And then we hear them describing who the Zulunation is. Okay, so all of those things not really necessary, okay? For us, at least. But in court, you do have to explain who the parties are, okay? Jurisdiction and venue. Again, another very important thing. Whenever a plaintiff is filing a lawsuit, they have the burden of proving to the court that that court actually has what is called jurisdiction. That means control of, right? That means, what's the word that starts with a P? Province of. There you go. Get my wheels turning. I didn't bring my latte upstairs with me. So yes, so the plaintiff has the burden of proving that this court has the jurisdiction, the province over, the power to hear this case. And so you hear plaintiff doing that in this second section as well, okay? Good stuff to know in general, but we're going to get into it, okay? So now we have the factual background. This is where plaintiff is going to detail the things that allegedly happened to him, right? The facts behind his allegations. So here we go. We're starting at paragraph 14. At all relevant times, plaintiff resided at Bronx River Houses, public housing provided by the New York City Housing Authority. Okay, so we know that plaintiff during this time was residing in NYCHA housing, which there, you know, are some NYCHA housing that is for people of certain socioeconomic strata. right? But there are also other NYCHA housing that is for communities that are socioeconomically at risk, right? That are suffering with some sort of socioeconomic challenge. All right, so paragraph 15. At all relevant times, defendant Lance Taylor resided at Bronx River houses as well, okay? All right, so then 16, we see that defendants Zulunation, Universal Zulunation, and XYZ Corp were headquartered inside Taylor's apartment. So this is how we're seeing the Zulunation being brought in, because allegedly Zulunation was headquartered at Afrika Bambaataa's home, which means that if this plaintiff is alleging that he was being abused in Afrika Bambaataa's home, then representatives of members of employees of Zulunation could have been present while these things were happening. So for those of you who have said, well, how is Zulunation involved? There you go. Paragraph 17, upon information and belief and at all relevant times, defendant Taylor was a well-known disc jockey, rapper, songwriter, music producer, etc., who is considered the father of hip-hop music. Oh, interesting. Can I tell you guys, some of you may come at me for this, I've never listened to an Afrika Bambaataa song. I don't. Anyway. All right, so they described that Afrika Bambaataa's home was the headquarters now. Paragraph 22. Plaintiff met defendant Taylor in 1991. So John Doe meets Afrika Bambaataa, aka Lance Taylor, in 1991. Okay, paragraph 23. Plaintiff was 12 years old when he met Taylor. Upon information and belief, shortly after meeting defendant Taylor, plaintiff became a card-carrying member of defendant Zulunation and began attending Zulunation meetings. Aha! So it appears that Afrika Bambaataa, aka Lance Taylor, was recruiting young men to become members of Zulunation. That is the allegation here. Interesting. Paragraph 25, shortly after, 26, shortly after meeting defendant Taylor, plaintiff became a card-carrying member of defendant XYZ Corp. Okay, so I guess XYZ Corp is the corporate entity of Zulunation. That's the allegation, that XYZ Corporation is the corporate entity. You guys, someone is riding by on a moped with their dog. They have the dog like riding on the moped with them. Too much. So the allegation is that XYZ Corp is the corporate entity for Zulunation. So now we know how XYZ Corp is relevant. Okay. 27. Upon information and belief, plaintiff became a part of defendant Taylor's security team. Huh. You know, let me hop in the chat here because I'm wondering, at what age did this young man become a member of the security team? I mean, that's curious. Did he become a member of the security team at age 12? I mean, a 12-year-old is appropriate for a security team. Yeah, you know, there's a lot of things going on in these cases. You know, we've covered, or we're covering R. Kelly, we're covering Brother Polite, and now with this Afrika Bambaataa case, some very, very strange goings on. I mean, I'm trying to picture in my mind what age this young man could have been that would have deemed him appropriate to be security. Interesting. And also, allegedly, Hassan Campbell has alleged that he was also security as well, right? Hasn't Hassan Campbell made that allegation? So now we have more than one alleged victim saying that they were security for Afrika Bambaataa, that he was giving them job titles. Interesting. All right, so Tony Hayes would like to know, does John Doe need physical evidence for proof? Well, Tony Hayes, that depends. Now, would the case be stronger with physical evidence? Yes, that is an absolutely. With physical evidence, this case would be stronger. Does John Doe need physical? Does John Doe need physical evidence to file this lawsuit? Not necessarily. Okay, in the early stages of a lawsuit, the burden of proof is not as high. As each stage progresses, the burden of proof will become higher and higher. More than likely, Afrika Bambaataa's counsel will file a motion that will challenge this suit, usually a motion to dismiss, right? Saying that there's not enough evidence. And the response to that motion is going to be yet another step up, right? They'll have to come in with a higher level of proof to beat that kind of motion. And then the back and forth will continue. And if they can continue to beat each evidentiary stage, then they'll continue to progress with their lawsuit. Okay? All right, Nappy Yankee has said it. Okay, he has spoken. Thumbs up, subscribe to the channel, share this video. Listen, if you're here and you're not subscribed, what are you doing? I mean, what are you doing? You know, because where else are you going to have a realistic adult conversation like this? Okay, let's be real. Okay, everywhere else you go, it's going to be mess, stress, and drama. All right. Honey Bee says, security, if young could have been used to bring in fresh young victims, maybe. Interesting thought. Interesting thought. Interesting opinion. Okay, Trip C's Treehouse. I like the name change, by the way. It's dope. Peace to you as well. All right, and True Soldier is saying that he thinks that security is another name for groupie. What say you out there in YouTube land? Okay. All right. I'm going to go back into our lawsuit. You guys, I am, can we talk for a second? Because, I talk to you. I'm deeply regretting that I did not bring my latte upstairs. I'm having deep regret. I always have my beverage, and I not only don't have water here with me, I don't have my latte. I'm having deep regret about this because I'm going to get the cotton mouth at some point. Hey. All right, let's dive back into the lawsuit. So let's go over here to, I don't even know what page this is. I think this would be page 5. So paragraph 28. Shortly after plaintiff met defendant Taylor, plaintiff began to volunteer performing administrative work inside defendant Taylor's apartment, which was known as a Zulunation headquarters. Yet another pause. We have to pause yet again. So we know that plaintiff allegedly met defendant Taylor, aka Afrika Bambaataa, when he was 12 years old. So now we are hearing that a 12-year-old became a member of Zulunation carrying a card, allegedly a part of security. Now we hear volunteering, performing administrative work. He's 12 years old. I mean, what? There were no adults that could have performed the administrative work inside a grown man's apartment? Okay, paragraph 29. Look, I can't even get my words straight. Because when I hear these things, I think to myself, can someone please protect the children? Can someone? Anywho. Paragraph 29. Upon information and belief, shortly after plaintiff met defendant Taylor, plaintiff began to work performing administrative work inside of defendant's apartment, which was also known as Universal Zulunation headquarters. So they're tying each defendant, right? So they repeated it for Zulunation. They're going to say it again for Universal Zulu. They will say it again, as you see here in paragraph 30, for XYZ Corp. Why do they do that? Well, they need to establish, right? Plaintiff needs to establish that he has the right to sue each defendant. He can't just sue en masse or en masse this big conglomerate of defendants. He has to explain why he's suing each of them. So every allegation will be repeated for each defendant every time. Okay? All right, paragraph 31. Defendant Taylor would invite plaintiff to his apartment, known as the Zulunation's headquarters, several times a week, and encourage plaintiff to exercise at the gym located within defendant Taylor's apartment. Okay, yet again, we have an adult who is telling a child that they are not related to hang out with them, to come over to their home, to work out at their home. All righty. All righty. Oh, Tripsy's Treehouse says, I have a present for you. If you so choose to use it, keep an eye on your email. Well, I love presents. And while we are all here together, right? You, my friends, me, your friend, and Tripsy, I am in my email right now, Tripsy. Whatever it is, you're welcome to send it whenever you like. And my email comes straight to my cellular device. And we can check it while we're all here together. Okay? Oh boy. All right. So Zen La says, hello all. Is it possible that Hassan Campbell is John Doe? Is it possible? Yes. Do I think it likely? No. And here's why. Hassan Campbell is already in the public, so I don't think it likely because I don't really think that he would sue as a John Doe, right? That's the first thing. And the second thing is, I don't think this young man is the same age as Hassan Campbell. I could be wrong on that, but I don't think that this John Doe and Hassan Campbell are the same age. I don't think. Okay. Okay, so let's get back into the suit, shall we? So we are here at paragraph 32. So we've already gotten past the part where Afrika Bambaataa was inviting this 12-year-old to hang out at his apartment and work out in the gym at his apartment. Upon information and belief, defendant Taylor would comment about plaintiff's muscular body and would touch plaintiff on the shoulders, biceps, and torso while plaintiff was exercising at defendant's gym. Oh my goodness. Ooh, 33. Defendant Taylor eventually began to inappropriately touch plaintiff in his blank areas while plaintiff was in defendant Taylor's apartment. Again, do you all see why Zulunation and XYZ Corp and ABC Company and Nation of Shaka, Zulu are all defendants? Do you see why? Because if these things were happening, as plaintiff alleges, someone else saw something. Someone else knew something. Somebody else in Zulu Nation saw something or knew something if this was happening. And that is why they're defendants as well. Okay? Because people, you cannot see these things and be complicit in them. If you see these things and you do not take active steps to stop them, you are complicit. All right. Back into the lawsuit now. Oh my goodness. Paragraph 34. Whew. Defendant Taylor eventually encouraged plaintiff to watch blank videos while in defendant Taylor's apartment. Defendant would also encourage plaintiff to blank in the presence of defendant Taylor while watching blank videos. Eventually, defendant Taylor began blank in the presence of plaintiff. Now, again, if for some reason me using the word blank bothers you, okay, remember that there's an algorithm here on YouTube and we want to have this conversation. We don't want it to be suppressed, right? So if you want to see this documentation in its entirety, you can go onto eCourts. The New York State system is called eCourts. It is free to search for cases. You can search with this index number. Let me copy and paste it and put it in the chat. You can search with this index number. You can bring up this case yourself, and then you won't have to, worry about me using blank to censor certain things. Okay? All right, here we go. Plaintiff then alleges that eventually things progressed to mutual M-word. Plaintiff alleges that during his visits to defendant Taylor's apartment, so John Doe says that while he was visiting Afrika Bambaataa's apartment, Afrika Bambaataa eventually began to S-word him, okay? Plaintiff goes on to allege, we're here in paragraph 37, that he became a victim of trafficking as Afrika Bambaataa would take him to other locations to offer blank to other adult men. Let's pause for a moment and have that conversation. So what you're hearing here is that not only is John Doe saying that he was abused by Afrika Bambaataa, right? Afrika Bambaataa also allegedly took this young man 2 other places where other men abused him as well. I mean, so what we're hearing is not just individual victimization, which, yes, Miss, oh, that tongue twister of a name, yes, Miss Me, Miss Mo, it's disturbing. It's disturbing, right? Because we're not just hearing that someone, it's disturbing enough to hear that someone was victimized by one person. But we're hearing that allegedly this young man was transported around to be victimized by other people. Now we have to stop and have a moment, right? Amazon is delivering a package. We have to stop and have a moment, right, about certain types of cases. So for those of you who are familiar with the R. Kelly case and what's going on there, you know that when people are being transported, it can trigger federal action. Okay, so depending on where this young man was being brought to, it is very possible that we see some sort of federal action here in the future, because we hear that this young man was being allegedly brought to other places to be taken advantage of by other adults. Okay, now Truth Soldier said something interesting that I want to address. Truth Soldier says, let's start with the parents. You know what? Let's have that conversation, shall we? Let's have that combo. A lot of people want to have a conversation about parents when we talk about these cases. And as you know, I approach these cases as impartial as I can be. And so I'm not going to sit here and say that it is unreasonable for someone to want to consider where the parents were or what was going on with the parents. Okay, I'm not going to sit here and say that. But here is what I'm going to say as well. If you notice the trend with a lot of the victims in these types of cases, you will notice they had parents that were working a lot. You will notice they had parents that were single parents. You will notice they had parents that were ill. You will notice, do I need to continue? Predators know what kind of victims to choose. That is why it is up to us as adults to clamp down on predators. A predator knows when a child has a sick parent, or a parent who's a single parent and is always working, or a parent who's incarcerated, or, right? A predator knows who to prey on, which is why as adults, the healthy, responsible adults of this society, we got to pitch in. We have to get back to villages raising children. That's what we got to get back to. Okay. I'm off my soapbox. Education and Learning says, I love the vibe in here. It's real groovy. Thank you. We try to keep it groovy and, you know, try to have a nice atmosphere. And hello to Let Me See Your Transcript. I see Let Me See Your Transcript is in the building. All righty. Senorita Flowers says, you explain things so clearly. Thank you very much. Gracias, senorita. All right, let me get back into this suit. I had to take a break because this is just so much. This is so much. Let me highlight this comment really quickly. Asia Henry says, men in the community know who the predators are because they hang out with them. They just cover up for their homies. Sad. Okay. Let me hop back into this lawsuit. We are here at number 38. So plaintiff alleges that these things took place between 1991 and 1995. So if you're doing the math here, if plaintiff was allegedly 12 in 1991, and these things took place when he was approximately 12 to 16. Okay. Oh boy. Alrighty. Paragraph 39. As a direct result of Afrika Bambaataa's criminal conduct described herein, plaintiff suffered physical injury, severe and permanent emotional distress, mental anguish, depression, and embarrassment. Plaintiff was prevented from obtaining the full enjoyment of life and has been unable to keep a steady job. As a result, plaintiff has incurred loss of income and or loss of earning capacity. So teaching moment. How can a plaintiff prove, right, that they had all of these psychological injuries? Because, yeah, a plaintiff can say, well, I suffered emotional distress. I have mental anguish. I have depression. I was embarrassed, right? A plaintiff can say these things. But the question is, how can a plaintiff prove these things? How can you prove mental anguish, depression, embarrassment, right? So, what say you out there? And if you're catching this on the replay, hello, how are you? Nice to see you. What do you all think out there in the chat? How do you think a plaintiff can prove mental anguish, emotional distress, depression? What kind of evidence do you think that a plaintiff could put forth to the court to prove that they are suffering with these types of mental, psychological injuries? All right, I'm going to give you all a moment. Okay. So I have an email from Tripsy's, what's the new name? I don't want to mess it up. Tripsy's Treehouse that I'm checking out now. All right, so I'm in the chat and I see we're asking all the right questions. Let me first say thank you to Kate and Pat for the $9.99 super chat. Kate and Pat says, I have friends who didn't tell their parents until they were adults. Yes, you know why? The psychological anguish, the fear. This is why the CVA extended the age, because they realized that people have things that happen to them at 12, 13, and oftentimes they can't even talk about it until they're 56. You know, it takes years to come out of that. Thank you so much for the super chat. My Cash App is also pinned. Again, if you send a Cash App and you do not want me to thank you on air, just put an NA in the description and I'll know that you do not want to be publicly mentioned. Okay? Thank you so much for the super chat. All right. And let me see your transcript. Let me see your transcript. You are the winner of today's amazing chat member award, right? Here we go. Testimony from family and or a psychologist showing change in behavior. Ding, ding, ding. That is how the plaintiff could prove mental anguish, emotional distress, depression, right? Testimony from an expert, from a psychologist saying, I've been treating John Doe since such and such year. I, received a conversation, or I had a conversation with John Doe in which John Doe described these things that happened to John Doe as a child. I was able to pinpoint those things as the root of John Doe's depression, anxiety, anguish, right? Things like that, feelings of embarrassment. So an expert witness is what is going to be needed here. And or medical records from a psychologist, okay? And I also saw another thing I wanted to highlight. Asia Henry said, work history, mental health treatment, drug abuse history. Yes, so work history. Work history is something that can be used to prove the, I'm asking for my latte to be brought to me. Something that can be used to prove the loss of wages, right? They can prove that John Doe has been unable to work steadily for all of these years, okay? Truth Soldier said it as well, criminal and mental health records, okay? Tony Hayes has a question about Larry Nassar. I haven't looked into that much yet, Tony Hayes, so I don't have an answer for you just yet on that one. Okay, QT1 wants, let me see your transcripts to send her award. No, QT1, if you want an award, you have to win it yourself, fair and square, okay? All righty, let's get back into the suit. Okay, so, oh my goodness. Paragraph 40, plaintiff only informed his mother of the aforementioned events while he was in his 30s, right? So you see how long it took plaintiff to grow comfortable enough to even be able to tell his mother what happened to him. This is the reason that the CVA extended the statute of limitations, okay? Here we are going into the first cause of action, right? So this is specifically the allegation of assault against Afrika Bambaataa, specifically the allegation that Afrika Bambaataa assaulted this young man, okay? So they say here we want to incorporate some things that we've already said earlier in the lawsuit. That's part of the course. They then go on to reiterate some of the things that they've already said, talking about things that Afrika Bambaataa allegedly did to this man when he was a minor, and also reiterating that Afrika Bambaataa allegedly brought this minor to other adults for them to do the same. Okay, so they reiterate that. They then get into civil battery. They start to discuss in paragraph 51 that Afrika Bambaataa intentionally did these things, right? He intentionally allegedly assaulted this victim. And so your question would be, well, what is the need for them to use the word intentionally? Because you would think that if they're making these sort of allegations, well, of course, Afrika Bambaataa knew what he was doing. Well, you might think so. But if you're making this type of allegation, the law requires that you prove intent. So that is why they are specifically saying, this is why plaintiff and his attorneys are specifically saying intentionally, because they know that is one of the requirements under the law. Okay. Asia Henry, I'm not going to highlight your comment just for your own privacy. But I do want to say that, my heart goes out to you, as I've said on these sort of topics before. And I hope that you're getting, support from loved ones and from possibly a counselor of some sort. Okay. And my heart goes out to you. Okay. Let's dive back into this suit. I may have to pause you all in a moment because, as I said, I'm visiting family. So there's a bit of, there are other people alive around here as well, right? I'm not on an island. Okay. All right. So they reiterate some of the past allegations about what Afrika Bambaataa allegedly did to this young man. They then get into Afrika Bambaataa allegedly transporting this young man. Okay. Now they get into some more allegations about intent. They say specifically that defendant Taylor, so AKA Afrika Bambaataa, knew that his extreme criminal and outrageous conduct. Mac is going crazy. Knew that his outrageous conduct. Mac. One moment, you all. Let me calm Mac down. Okay, alrighty. So they say that Afrika Bambaataa knew that his extreme criminal and I thought I had calmed him down. Come here, boy. Come here. Not you, Rhino. Come here, Mac. There's another dog here who's trying to come when I'm calling Mac. Come here. Come. Knew that his extreme criminal and outrageous conduct would give multiple adult men. Oh, goodness. One moment, you all.
Rhino, what's up, man? Long time.
Someone said in the chat, even Mac is disturbed by these allegations. Yes, we're all disturbed. Even Mac is disturbed by these allegations against Afrika Bambaataa. See ya. Have a good time, y'all. Saying goodbye to a couple. All right, family members. Okay, so let's get back into it. So why do they specifically say that defendant Taylor, aka Afrika Bambaataa, knew that his conduct would give rise to other men abusing this young man allegedly? Here's why. Because if plaintiff only proves that Afrika Bambaataa allegedly did ABC to him, then he can hold Afrika Bambaataa responsible. True. But if he can also prove that Afrika Bambaataa facilitated his abuse where he was being abused by others, he can hold him accountable for all the things that happened to him at the hands of these other men as well. So it is very important that he establish that Afrika Bambaataa knew the purpose that he was bringing this young man there for, and knew that allegedly this young man was going to be abused. Okay? Mac, say hello to everyone. You've been disturbing them. So you might as well give them a hello, give a little wave. Hello, everyone. Okay. All right, I see some questions. Yvonne May would like to know, will the others be named or called to testify? So it is possible that the other men will be named. That is a possibility, okay? Or they could remain anonymous. You never know. Teddy Woodson has an interesting question. Why is the accused called the defendant when he is presumed innocent, and the plaintiff is called victim when they have not proved their accusation? Now, Teddy Woodson, a defendant is not an accusatory term. A defendant is a legal term. If you are sued, Teddy Woodson, because you accidentally ran over someone's foot with your car, right? You would be the defendant. It's not a nasty name. It's not a derogatory name. It is because you are the person who is defending yourself. You see what I did there? Against the lawsuit. The plaintiff is called the plaintiff because they are the person that is filing the complaint against the person who is defending themselves. The who? Defendant. See what I did there? So defendant is not a derogatory term, okay? And someone is called a victim because they are alleging that they are a victim. Pretty basic, okay? There's no conspiracy at all behind that. Okay. All right. I don't see any other questions. So let's hop back in. We're not going to be on here much longer, you guys. I'm on Information Man's channel at 4:30. So I'm not going to stay here too long on this, okay? Mac, would you like to go back down? Ooh. I think he's dying to go back down. Okay. Go ahead, Mac. Okay. Let's get back into, let me take this comment down. I see one of my faves. Hello, Mara Cherise. How are you doing? All righty. Pro Woman says, hey, his name is Mac, by the way. It's M-A-C. I'm going to put it in the chat for you guys. But Pro Woman says, hey, Mac, looking good. Bark, bark. Mac is fierce. He's vicious. You know, he fiercely protects me. All right. Yes. 4:30 EST, Nappy Yankee. I'm on Information Man's channel at 4:30 EST. So, you know, I'm not here much longer. Okay. All righty. So let me hop back into this suit. Okay. So here we are, 61. We're on page 9. And I think there are 15 pages. Okay. So we're going to round it up here. We're going to keep it moving. As a direct and proximate cause of defendant Taylor's extreme criminal and outrageous conduct, plaintiff suffered from severe and permanent emotional and psychological distress, including depression and mental anguish. Teaching moment. You see these terms here. You see direct and proximate cause. Again, in order for someone to sue another person and say that that person owes them damages, they have to prove that that person caused them to suffer some sort of injury. So that is why plaintiff is saying here, listen, Afrika Bambaataa's actions are the direct cause and the proximate cause of the injuries that I suffered. He caused my injury, and therefore he should be able, or rather he should be held accountable by the court. Mara Cherise says, my Rocky is that size, but don't trip. He don't play about his mama. That's right. That's right. My Mac is the same. Thank you for the $10 super chat, YaniTube. I hope I said it right. We appreciate it. Thank you. Thank you very much. Asia Henry, if you want to go to law school, it's never too late. Never too late. And the question is, can plaintiff bring suit against others? Yes, he can. He can also sue others individually, but remember, he's suing Zulunation. So perhaps and this is a bit of a conspiracy, this is a maybe, allegedly, maybe, some of these other men whom Afrika Bambaataa allegedly brought this young man to, perhaps some of these other men were members of the Zulu nation. Maybe, allegedly. Okay. All righty. Let's get back into it. So now we get into his fourth cause of action. He talks about negligent infliction of emotional distress, which is when one person does something that causes another person to have emotional distress, i.e., some sort of emotional disturbance because of whatever it is that that person did. Okay? Here we go. Plaintiff reiterates everything he has said earlier. Okay? Defendant Afrika Bambaataa breached his duty to exercise reasonable care when he escorted minor plaintiff to apartments belonging to adult men for the purpose of offering plaintiff to perform blanks in exchange for money. Now, whenever you see the term negligence, it refers to our duty to exercise reasonable care. So that's why you see that language being used. Okay, so what does that mean? Well, that means that in general, right, as a person living life, you have a duty to act in a manner in which you are exercising reasonable care. That means objectively, whatever it is you're doing, if someone else sees what you're doing, they should think, someone who doesn't know you, so totally objective, not subjective. If someone who doesn't know you at all were to see you and see what you're doing, they would think that what you are doing and the way that you are behaving is totally reasonable, right? That you're taking a reasonable amount of care in what it is you're doing. So here's an example. Let's say you decide to cross the street. You look both ways and then you cross the street. Anyone who sees you could say, oh, you're not being negligent because you're behaving in a reasonable manner. You're looking both ways. And then you cross the street. Now, if someone sees you not look and then just dart across the street, they would say, oh, well, you're being negligent because you didn't look both ways, right? So it's objective. It is when observed by a totally random person. Is your behavior reasonable? Is it okay within normative standards? Okay. So plaintiff is saying that, hey, a reasonable person, an objective person would look at Afrika Bambaataa's behavior in taking this young man to the apartment of these other men for the purpose that he did, allegedly, and say that he's not behaving in a reasonable manner. Okay. Latte for the win. Oh, it's 4:13. I got to hurry up and get out of here. Okay. I don't even know. Are you guys still seeing? I think you guys are still seeing the suit. I hope so. Okay. All righty. So we are here on what, page 9 still? All right. We gotta get it moving. We gotta get it moving here. Let me just make sure. Okay. All righty. So let's go into the fifth cause of action. We have gross negligence against Afrika Bambaataa. Okay, paragraph 69, defendant Taylor, Afrika Bambaataa, evinced extreme indifference. Ooh, okay. To plaintiffs, you want to talk about legalese, to plaintiffs' health, safety, and rights by breaching his duty to exercise reasonable care when he transported minor plaintiff to the apartments belonging to adult men. Again, we know what negligent means, right? So we know what this allegation is saying. Okay. They then say in paragraph 70, Afrika Bambaataa knew or should have known that his willful and malicious conduct would cause foreseeable harm to plaintiff, a minor child. All right. Now, what does that mean? This is what that means. Going back to our original example about you crossing the street, right? Now, totally objective person who doesn't know you, from the outside looking in. If you dart across the street without looking, any other person can say, well, you should have known that you could get hit by a car because you didn't even look. So here plaintiff is saying, Afrika Bambaataa, you should have known the harm that it would have caused me when you brought me, allegedly, to the apartment of these men for them to do what they did to me, allegedly. You see the connection there? Foreseeable harm. When someone behaves in a manner that is not reasonable and they can foresee that something bad could happen. You dart across the street without looking, you can foresee that you might get hit by a car. You do what Afrika Bambaataa allegedly did, you can foresee that it could cause the child mental, emotional, physical damage. Okay? All right, Nappy Yankee has said it and is saying it, and we thank him for being a great mod. Thumbs up this video, share this video, and subscribe to the channel if you are not subscribed. Also, become a member. My membership content is a different side of me, right? We talk about life. Recently, we talked about how to deal with conflicts in your family, okay? How to deal with conflicts with family members. And we have different tiers of membership. So join the channel for exclusive member content. All right, back to it so we can round this up. My laptop is dying. I got to hop on over to information, man. So we got to speed this up. All right, 6 cause of action. We now have negligence against the Zulu nation. Okay. Now, we see that defendants Zulunation, Universal Zulunation, and XYZ Corp had a duty to take reasonable steps to protect plaintiff, who was a minor child at the time, from foreseeable harm when he was in their care, custody, and control. Again, remember what I said about foreseeable harm and your duty to act in a reasonable manner. So when you flip that, and you remove Afrika Bambaataa and you put Zulunation, right? The allegation is Zulunation should have reasonably foreseen that these things could have happened to this young man. And once they reasonably, right, knew that these things could happen, then they should have been able to say to themselves, well, if these things happen, it could harm this young man, right? And so because they did not prevent these things, they breached their duty of care. That is the allegation here, okay? Okay, XYZ Corp Zulunation, 7th cause of action. Again, intentional infliction of emotional distress against the Zulunation. It's the same allegation as was made against Afrika Bambaataa, but it is just specifically in the terms of Zulunation, okay? So the allegations are not different, okay? Now here's something interesting though. Paragraph 81. We have to read this together. Defendants Zulunation, Universal Zulunation, and XYZ Corp engaged in reckless, extreme, and outrageous conduct by representing to plaintiff and his family that Afrika Bambaataa was safe and trustworthy, despite the fact that defendants Zulunation, Universal Zulunation, and XYZ Corp knew or should have known that defendant Taylor was using his position in Zulunation to groom and blank abuse children, including the minor plaintiff. Now listen, we're gonna end it there, okay? We may review the last page, but we're gonna end it there because we need to leave it there. That is the essence of this man's case against the Zulu nation. He is saying, listen, Zulu nation, you had your headquarters at Afrika Bambaataa's home. So you should have known the things that were inappropriate were happening in his home. Zulu nation, this man was using his position to recruit and groom young men, allegedly. Zulu nation, you should have known about this. There's no way that you could not have known, and that is why you're responsible as well. That is the crux of plaintiff's allegation against Zulu nation. Right? And the allegation that Afrika Bambaataa used his position in this organization to bring in victims, that is not only a very serious allegation, but also a poignant one, right? because it makes sense. Remember the conversation we had in the very beginning when we talked about these allegations and we said, 12-year-old doing security? Huh? 12-year-old doing administrative work? There are no adults in Zulu Nation to be security guards and do administrative work. There are a lot of things here that just from the outside looking in, you can say, we can see how plaintiff could allege that Afrika Bambaataa used his position to lure young men in. We can see that, okay? Allegedly. All righty, so listen, I gotta hop off of here. My laptop is dying, that's the first thing. And the second thing is I gotta hop on over to Information Man Show, okay? But per usual, it has been wonderful being here with you. You have been here for another installment of Empowered Esquire TV, where we arm you, where we empower you with legal knowledge. I hope you feel powerful because you are. Thank you for being here with me. If you are catching this on the replay, what say you? What do you think about this case? Do you think that John Doe has brought a strong suit here? Or do you think that perhaps this lawsuit may not go anywhere? I'd love to hear your thoughts. And if you have any questions, feel free to drop them below as well. All right. See ya.